Tēnā koutou katoa. No mai, haere mai, and welcome to today's webinar exploring the rights and needs of migrant victims, survivors of family violence within immigration policies and practices. My name is Charlotte Moore. I am the kaiwhakahaere for the New Zealand Family Violence Clearinghouse, and it is my pleasure to be hosting our webinar today. We have 5 fabulous panellists joining us today who I will introduce shortly, but before I do, I'll just run through some housekeeping for our webinar. And just a little note, I'm actually recovering from COVID at the moment, so if I am a little bit croaky, I do apologise. In our webinar, as attendees, your microphones and cameras are off. No one can hear or see you. You can use the chat box to share comments. You can set those comments to go to all panellists and attendees, or just the host and panellists. You can use the chat box if you have technical issues, and we will try to help. Please use the Q&A box for questions for the panellists. Our panellists will answer questions at the end, but you can ask questions at any time. We are trying the Zoom automatic closed caption service. You can turn this on by clicking the CC button on the bottom of your screen. We are not sure how well this will work. We will provide an edited transcript with the video recording. This webinar is being recorded and we will email the link to you. We understand the issues we'll be discussing today can be challenging or triggering. You can mute the sound or leave the webinar at any time. A recording will be available. We will provide a list of where to go for help at the end of the webinar, and we will also post contact details in the chat now. Please note that if we consider any comments to be disrespectful or offensive, we reserve the right to remove people from the webinar at our discretion. Our NZFVC staff, Megan Setti and Owen Lee, are in the background helping manage the tech issues, responding to your chat messages, and helping with the Q&A session. I also want to acknowledge that many of you, when registering for this webinar, asked about supports and resources to help victims. As many of you already know, these are currently limited, and our panellists will talk about these limitations more. If you have questions about specific situations, you can email us, and where appropriate, we will forward this on to the panel. Today, we will be talking about the challenges and barriers faced by victims of family violence in New Zealand's immigration policies. I want to note that there are many issues unique to the experiences of migrant victims of family violence, but today's session is specifically focused on immigration. Most of our discussion will focus on immigration policies, but the panellists will also highlight related policies where there are opportunities for change, including legal, financial, and social assistance. Members of ethnic communities and organisations working with ethnic and migrant women, including Shakti and Shama, have long highlighted specific risks of violence for migrant victims, including immigration-based abuse, and the barriers within the current policies that impact victims' ability to access help. Alongside the voices of community experts, there have also been numerous research reports over many years identifying barriers in immigration policies, including the 2007 report, Living at the Cutting Edge, research from the Ministry of Business, Innovation and Employment, of which Immigration New Zealand is a part, identified policy issues and INZ operational processing issues that present barriers to migrant victims obtaining family violence visas, describing how current policies and practices can contribute to preventing migrant women from seeking or receiving help. Most recently, a parliamentary select committee as part of an inquiry into migrant exploitation has also highlighted issues. The UN Committee on the Elimination of Discrimination Against Women has also raised concerns about immigration settings and their concluding observations on New Zealand's last periodic report. However, despite increasing awareness of the risks and barriers for victims and repeated calls for change, there has been very little movement in immigration settings and policies addressing family violence for migrant victims. So where does that leave us today? There is a lot of change happening now with immigration policies, but none of the current changes are addressing victims of family violence. Under the current policies, there is instead a risk that victims may lose their right to live in New Zealand and may be forced to leave the country, potentially leaving behind their children. Advocates for change are continuing to draw attention to the challenges faced by migrant women experiencing family violence. Green MP Jan Logie has recently introduced a members' bill protecting migrant victims of family violence to provide stronger protections for people in migrant communities who experience family violence, although this bill has yet to be drawn from the biscuit tin. Te Mahere Whai Mahi Wahine, the Women's Employment Action Plan, includes an action to review the immigration settings for migrants in New Zealand who experience family violence, to ensure that appropriate support is available, including visa categories that are more commonly granted to women, by the Ministry of Business, Innovation and Employment, Manatū Wahine Ministry for Women, and the Ministry for Ethnic Communities. We also have a new national strategy to eliminate family violence and sexual violence, Te Aotearoa, which was launched in December last year. However, although Te Aotearoa identifies control of visa immigration status as a distinct form of abuse and acknowledges the need for improved service responses for ethnic communities, including migrant victims of family violence, there are no specific changes to immigration policies and settings included in the current action plan. Finally, Immigration New Zealand has indicated there will be a review of partnership-based visa settings, including the Victims of Family Violence work visa in 2023. So does this review offer us hope that we may finally see an opportunity for meaningful change? Joining me today to talk about the challenges faced by migrant victims of family violence and the changes that need to be made to ensure their safety is a wonderful panel of experts who I will introduce now if they would turn on their cameras. Welcome, everyone. Vasudha Gautam is the Client Care Coordinator of the Refugee and Immigration Legal Advice Service at Community Law, Wellington and Hutt Valley. She's experienced in supporting and advocating for family violence victims and is herself a victim survivor. Silvana Erenchun Perez is the Strategic Manager of Shama Ethnic Women's Trust. Shama provides culturally appropriate support, advocacy and programs to ethnic women, their children and families. Silvana has also previously worked as a journalist, giving voice to groups not represented in traditional media. Sarah Croskery-Hewitt is a lawyer who worked with community law on access to justice for survivors of family and sexual violence and helped establish a specialist immigration law service at Community Law for migrant women experiencing violence. She's also currently completing research on immigration policies and family violence. Dylan, we got your camera working? Hopefully Dylan can join us online soon. She is a lawyer who currently works with Community Law Wellington and Hutt Valley in the Refugee and Immigration Legal Advice Service. She assists migrant survivors of domestic violence with visa applications and appeals to the Immigration and Protection Tribunal, and also works on migrant exploitation, work with employment, and will be doing research in this area as well. Finally, Megan Williams is a lawyer and a law reform advocate at Community Law Centres or Aotearoa, working in the areas of immigration and refugee law, social welfare and housing law, family violence and access to justice. She previously led the Refugee and Immigration Legal Advice Service at Community Law Wellington and Hutt Valley, including work related to family violence visas, and she helped set up the specialist family violence visa service for migrant women. So welcome everyone, and so glad to have you all joining us today. To begin with today, I'd like to hand over to Vasu. You've spoken previously about your own experiences as a migrant experiencing family violence. Would you start us off by sharing your own experiences of having insecure visa status and having to navigate New Zealand's immigration policies while trying to achieve safety and security for yourself and your children?
Thanks, Charlotte. Kia ora, I'm Vasu. I was myself, along with my boys, a migrant victim of family violence. And my own personal experience is a good example of what's wrong with the current restrictions on the family violence visa. I was a middle-class Indian woman put into an arranged marriage by my parents to someone who I very soon found out was an abusive thug. After 10 years of an abusive marriage, his company sent him to work in New Zealand and I moved here with him along with my 2 young sons. He was on a temporary work visa, and my visa depended on his. The abuse and violence I faced from him continued here in New Zealand and started to get even more extreme. As well as physical violence, I wasn't allowed to have friends or talk to neighbors. After being in New Zealand for 2 years, he applied for a residence visa. In deciding whether I should try to flee this abusive marriage, I faced the same fears and obstacles that all victims of violent relationships face. Could I get out of the house with my boys and to a place of safety? But on top of that, my immigration status, which was tied to my husband's, made things even more difficult and uncertain. I feared leaving the relationship before he was granted residence and thought that if I had stayed until then, I and my boys would have more security. In the end, one night, when things reached their worst, I had to leave with my 2 boys, 6 and 12, as I wasn't sure we would all survive the night. Soon, I found out that I was not eligible for the family violence visa. Because of that, I wasn't entitled to support from work and income. Now I had no money and I had to borrow to be able to buy food for my boys and me. I had to find work urgently, and my mother came to New Zealand to help with my young boys so that I could work. I had to work long hours, but that meant I couldn't be there for my boys during a time when their home life had been turned upside down and they felt very vulnerable. Early each morning, as I left to go to work, I had to say goodbye to my 6-year-old who would start crying and break out into a sweat because he wasn't sure I would be coming back. I wish I could have been there for my children at the time when they needed me most. There was also a criminal trial, and I and my older boy had to give evidence, and there were also a lot of family court processes to go through. At this time, I was also worried that my boys could be kidnapped by their father on their way to or from school. I had to leave it to my mother, a woman in her 60s, to keep them safe. So I had to work, but finding work was not easy. Because I couldn't get a family violence visa, which lasts for 6 months, I was only able to get short-term work visas, and I had no certainty that they would be renewed. That made my position very insecure and made it difficult to find work, as most employers were not interested in employing someone with short-term visas. I have been working at community law for over 6 years now, and I have met a number of other migrant women who, like me, were victims of family violence and tied to abusive partners who were on temporary visas. It became clear to me that my own personal story was just an example of a bigger immigration policy problem. I have seen these women face the same uncertainty as I had to face, not knowing how they will be able to support themselves and their children, or whether they can even stay in New Zealand or not. I hope that sharing my story brings more attention to this issue and helps to bring about meaningful change. Thank you.
Thank you so much, Vasu, for sharing that personal story, which really does highlight the realities for migrant women experiencing violence and just those significant barriers to being able to achieve safety and well-being. Thank you very much for that. Sarah, if we could move to you next, it would be really helpful, I think, for all of us and our viewers especially, to have a kind of overview of what current immigration policy looks like and where some of those sticky points are. So if I could hand over to you.
Kia ora, Charlotte, and kia ora, Vasu, for sharing your story. Thank you so much. I think that gives our audience really great context for what we're going to be discussing over the next hour. As you mentioned, Charlotte, under current immigration policy, unfortunately, victim survivors of violence who don't yet have residence are often at risk of losing their right to remain in New Zealand if they separate from a violent partner. And this is because their visa and their pathway to residence will often depend on the partner's support. This means that if they separate, they're at risk of losing the life they've built in New Zealand, their employment, any support network they have in New Zealand. They might even face separation from their children, or return to a home country where they'd face very serious hardship or stigma. And obviously this is a huge barrier to migrant women seeking help if they experience violence. And just a note on that, I am using gendered language and will be throughout my discussion. I'm in no way meaning to suggest that people of all genders cannot experience family violence. I'm just using this language to reflect the dominant experience of the clients who we've assisted at community law and the gender dynamic in the majority of appeals that relate to family violence visas. So New Zealand has a specific victims of family violence visa scheme that applies to certain victim survivors who are in this situation. But as you've heard from Vasu's story, it excludes quite a large proportion of women. And New Zealand's scheme is actually a lot narrower than similar policies in countries like Australia, the UK, and the USA. So there's two victims of family violence visas. Firstly, there's a 6-month, very short-term work visa, and a wider group of victim survivors can access that. Secondly, there is a victims of family violence residence visa, which allows an applicant to remain in New Zealand permanently, but is quite a bit harder to access. In fact, I think there's been an average of about 43 per year over the last 5 years have been successful. And women seeking the residence visa normally have to apply for the work visa first because the residence can take quite some time to process. I've put the key visa criteria onto this slide so that everyone can follow along. Bear with me, I know it's a little bit lengthy, but these criteria come from the immigration instructions, which are approved by the Minister of Immigration. So the first requirement is that an applicant must have been in a partnership with a New Zealand citizen or resident, which, as you heard from Vasu's story, means that women whose partner is on a temporary visa can't access a family violence visa, even if they were on a pathway to residence or even if they'd already submitted a residence application. And at community law, we've encountered many, many women in this situation who are facing very severe violence, but separating and losing their right to remain in New Zealand is just too high a risk for them and their children. So they determine that it's not safe to separate, or they have reconciled in some cases with their partner because of the risks of having to leave New Zealand. The second requirement is the applicant must have intended to seek residence based on her relationship. The third requirement is that they have separated due to family violence, and only 4 types of evidence of family violence are accepted. There either needs to be a New Zealand conviction for family violence offending, a letter from New Zealand police stating that they are satisfied that family violence has occurred, a final protection order, not a temporary one, only a final one is acceptable, or 2 statutory declarations from certain designated professionals that state that the professionals are satisfied family violence has occurred, plus there also needs to be an additional declaration from the applicant herself. These professionals have to be independent of one another, so they have to be from different services, and they need to be either registered as social workers, doctors, nurses, psychologists, counsellors, or some designated women's refuge and Shakti staff can do them. The fourth requirement is where New Zealand is especially different and much more restrictive than other comparable countries. And this is the requirement that for residents, an applicant has to show she's unable to return to her home country because she would be at risk of abuse or exclusion because of social stigma, or she would have no means of financial support. And a really high threshold has tended to be applied to the unable to return home test. Women need to show they would face quite a severe situation to meet it. And realistically, this limits access to the visa only to women from regions that are perceived as especially hostile to separated women. It's also the criteria that seems to exclude the most victim survivors. So of the published appeal decisions relating to family violence visas, this requirement has been the main reason for 80% of the applications under appeal being declined. And as I mentioned, there's no requirement like this in countries with comparable visa schemes. So internationally, family violence visa schemes focus more on ensuring that no woman who had a pathway to residence is penalised by being sent home if she reports violence. Personally, I think that New Zealand's unable to return home requirement means that ours functions a bit more like a form of refugee status for a smaller number of women who can show significant risks in their country of origin. So there's several other requirements that I haven't put on the slide, as they don't tend to cause as many difficulties, but sometimes they can. These are the requirements that an applicant needs to be physically in New Zealand, needs to be of an acceptable standard of health, and needs to be of good character. And at community law, we have seen the requirement to be physically in New Zealand can be quite problematic for women who experience a form of abuse called transnational abandonment. And that's something that I will return to a little later, but I'll leave it there for now and hand over back to you, Charlotte.
Kia ora, thanks, Sarah. You can start to see where there's a huge number of hurdles that have to be overcome to actually be able to make use of these visa systems. Silvana, I might switch to you. The visa criteria includes a requirement to prove the victim is unable to return to their home country, including a risk of abuse or exclusion. Can you talk about why this is difficult or impossible to prove for some women?
Thank you, Charlotte. Kia ora, everyone. Well, like Sarah was saying, that is one of the main reasons why women get denied the residency here in New Zealand. There is many regions, or not many, but there is a few regions around the world where women get really by legislation or by the government really punished if they leave their husband, or if they stop the violence, or to stop the violence, they stop the relationship. So countries like from the Middle Eastern or with the Islamic government, maybe it's easy, but for people from countries from Latin America, or even India or Fiji, where we're supposed to have democratic governments, it's not seen as dangerous for us to go back home. But it's very depending. There is no way to prove, that maybe your community is dangerous, maybe because you come from a family which is really religious, and religious is very important, and you will get segregated. And they are not going to sign a letter saying, yes, my daughter is going to be at risk, because they don't see that badness. So how you can prove that? Also, we know that many of our clients have received threats in terms of if they go back to their countries. But again, it's very hard to prove the future, or how we can prove these threats. So in that make it very difficult for women, to go back, but you can prove it, because I have seen women from Latin America that sometimes getting a birth certificate takes like 6 months to come into New Zealand, So there is also those bureaucratic or post issues that make it really hard to get those proof, or to get witnesses that they will be brave enough to challenge the community where they live in, to say, yes, things here will not be good for this woman. So I think, especially for women, for example, from the US, like I said, from Latin America, it is really hard to prove, because our countries are not so against. But even from India and Fiji, that some people might think like, oh, actually those countries too. Well, it's very different if you come from Mumbai than if you come from a little village in a rural area, where the discrimination, and again, the stigma could be very hard on that woman. So yes, that make it very hard for us to prove. And that like Sarah was saying, you can't just go back to your country, because you may not be able to come back, so you can't even go and get the proof yourself. You need to rely on from here to try to do your best, all this within the 6 months that work visa give you, at the same time that you are fighting with the courts, and so many different issues that you are facing when you are trying to leave that relationship. So it is really hard to expect women to be able to give that fight as well, or to do that proof, considering everything that they are going through at that moment.
Kia ora, Silvana. Could you also talk about the risk for women being returned or deported to their home country without their own children?
Well, so again, usually women or people who have experienced violence and they are trying to address the situation, they are going through multiple courts or multiple processes, and those processes not always communicate in between each other. So, for example, the immigration could decide that Chile, in my case, for example, is a perfectly safe country to go back because I will not face risk of losing my life or exclusion. But at the same time, if I am not having a good situation, or if I don't have much support, the family court may decide that my children are going to be best placed here in New Zealand with the family, for example, of the perpetrator, or with the network concerned. When us ethnic communities, many times we face discrimination, and part of the discrimination that we face is thinking that our countries are never as good as New Zealand. You know, so when the family court is thinking on the best for the children, many times they do think that New Zealand will be the best for those children. But even as a woman, if I have to leave New Zealand and I am not sure how it's going to be back home, I may be scared that the situation is not going to be good. I may need to think, maybe I need to decide to leave my kids here because they are going to be better looked after than what I can provide there. We also have seen men that threat women, or the perpetrator that threat women, you know, in terms of, I will not let you take the children, I will prove. So there is so many situations where the woman at the end could be leaving home without, you know, the children. I remember when I first started working at Shama in 2015, I used to tell women, don't worry, speak up if you're facing violence, because we are here, we are going to help you, everything is going to be okay. Until the first woman that it was going to be not deported because she wasn't going to be waiting until deported, but her visa got canceled and she was one of those people that they were unable, who improved that it was unable to go home. She was from Fiji, and she did tell me, Silvana, you would have told me the truth, I will have wait for another 6 months until I get my visa, and I will take the bus for 6 more months, you know, and that will mean that I could stay here. And after that, for me, it was a shock, you know, I need to change the way that I speak, and now I have to tell them, look, violence is never good, you need to speak up, but there may be the risk that you need to take home. And many of those women, then they will not speak up. It's too much, that risk. We don't, I know that not everyone gets deported, but we feel it as deportation because we are being asked to leave this country, you know, and without consideration of the networks that we're here, the family that I may have, or the friends, panel, the work. Yes.
You can, yes, absolutely understand that the risk of separation from children is an incredible barrier for women to actually be able to become free from violence. You know, if that risk is that their children will remain here while they have to go home, being a significant deterrent. Thanks, Silvana. Vasu, if we could come back to you, can you tell us about the issues with the current visa requirement that victims are eligible only if their partner is a New Zealand citizen or a New Zealand permanent resident?
Yeah, so if your partner is not a citizen or a resident of New Zealand, there is no clear pathway to get a family violence visa, which lasts for 6 months. This makes women stay in unsafe relationships with the abuser and not leave. Or sometimes they even decide to go back to their home country where it's unsafe for them as well. This was the case, same in my case, that I wasn't eligible for the family violence visa. So I had to be dependent on short-term visas. And it's difficult to find work on short-term visas. When we see a client at Community Law Wellington and Hutt Valley, and we say that leave the relationship, we'll have to make a request to the minister because it will be on the minister's discretion, that they sometimes never come back to us as they find the process too uncertain. And also that this process can take a very long time. It took a year for me to get residence, and I had to go through criminal trial, family violence, family court processes without knowing whether I will be getting residence or not. As they cannot get the family violence visa, they can only get short-term visas, which have to be renewed frequently. This was the situation I was in. And as I said, I got my residence through Community Law Wellington and Hutt Valley making an application to the minister. So it just makes things really uncertain for women. We see women struggling with this decision to separate as they are then scared of the consequences, with the process being too long and not sure whether in the end they will get residence or not. Yeah.
Thanks, Vasu.
Thanks, Shama.
Sarah, if we can come back to you, what are the issues with the evidence that visa applicants are required to provide that demonstrate family violence?
Yeah, so as I mentioned earlier, there's only 4 accepted forms of evidence of family violence. and they all require the applicant to have either sought help through the justice system or from 2 designated professionals. And there's no discretion for immigration officers to accept other forms of evidence. And that can be a huge barrier to accessing the visas, because there's a lot of really good reasons why a victim survivor it might not have been practical for her to access the justice system or 2 different services. Most obviously, she might have been scared to seek help from police or services because she knew it could jeopardise her visa if the violence was known by immigration. So that can happen in a couple of different ways. If she reported her partner's violence and he received a conviction, he could then fail to meet the character requirements to sponsor partnership visas in future. Alternatively, we've also seen instances of immigration deciding that there's been violence and that means that a relationship doesn't meet the genuine and stable relationship test that's required for partnership visas. So that's obviously, front of mind for migrant victim survivors when they are considering disclosing to someone, is the risk that it could get back to immigration and jeopardize their visa. She might also struggle to access police help or other services because of limited English, or might have feared racism or a lack of understanding from police or services. She might have had negative experiences seeking help in the past, or negative experiences with police in her home country. There can be financial or transport reasons that mean she can't access 2 designated professionals. And it's important to remember that the professionals that are accepted are people like doctors, psychologists, and counsellors. So they're often expensive to see, and often women don't qualify for publicly funded healthcare when they're on a temporary visa. There's also problems with a really narrow range of professionals that are acceptable. So, for example, experienced women's refuge or Shakti staff can provide declarations, but services like Shama and Shine Refuge are not able to. We've also had clients who saw registered psychotherapists who were extremely experienced in family violence and had worked in the area for decades, but because they're not a counsellor or a psychologist, they're a psychotherapist, they're not accepted. In terms of the justice system forms of evidence, like final protection orders or convictions, they can take months to a year or more to secure. And another problem we see is that protection orders are often not made final. So what happens is normally a temporary protection order is made very quickly, but that's not sufficient evidence for the policy. And then later down the track, the family court makes a decision about whether to make it final. They often don't, not because there's any doubt about violence having occurred, but if there hasn't been much post-separation violence recently, the family court might decide the order is no longer necessary. That doesn't mean violence didn't occur. Sometimes also we've seen family lawyers encouraging women to settle for an unenforceable undertaking not to use violence rather than pursuing the final protection order, which might mean they don't then have the evidence for a family violence visa application. So I really think there needs to be a discretion introduced for immigration to accept other kinds of evidence like there is in several other countries.
Thanks, Sarah. We also know, of course, that there's quite regional variability in terms of access to specialist services for support. So where women or migrant victims are located around the country is going to also impact on their ability to find those safe places for, to reach out or to find the support that they need that is appropriate for their needs as well. Thanks, Sarah. Megan, if we could come to you now. What kind of legal help can victims access?
Thanks, Charlotte. First of all, just wanted to acknowledge the complexity of the situations that women are often in. And I think Vasu, Sarah and Silvana have really outlined or indicated some of the complexities that are involved in the applications. So it's very difficult for people to navigate these applications on their own, particularly when separating and are dealing with multiple stresses and other legal processes, often with having to go through potentially family court processes or even criminal court prosecutions of their abusers. So legal support, we think, is really essential. And unfortunately, legal aid is not available. So while legal aid is available for family court processes like protection orders, it's not available for the immigration side of things. Most of the women that we see have experienced financial abuse and have very restricted finances, certainly not the ability to pay an immigration lawyer. And there are community law centres that can provide assistance with these applications, but it is a fairly specialist area of immigration policy. Not all community law centres can provide this kind of specialist service that centres like Wellington and Hutt Valley do. And one of the difficulties for community law is that we're not funded to do this work, and our funding model does not fit well with these kind of applications. These applications tend to take a really long time. A lot of hours of legal work goes into these applications, and our funding is really limited to seeing one client once in the space of a year. So it is a struggle for community law centres to provide the specialist advice that's required. And there are other costs as well. If a residence application is declined and it's appealed to the Immigration and Protection Tribunal, that's a $700 appeal fee. And I have had clients who have decided not to appeal based on that cost because they simply haven't had the money. So yeah, it's an incredibly challenging area, and one that could at least be assisted by making legal aid available.
Thanks, Megan. Could you also talk about the issues with the temporary family violence visa?
Yeah, and I think Vasudha has highlighted these really well, with the problems with the visa generally only being granted for 6 months. If an applicant applies for residence at the same time, then the work visa can be granted for 9 months. But 6 months is a very short time to try and get your life in order after going through a separation. And like I mentioned, all the other processes that may be going on, you know, with having to move, going through a family court process, and looking for employment. I mean, many of our clients have not been working up to this point. Many do have to look for employment, and it's so hard to get a job if you've only got 6 months left on your visa. But when you take into account the time it takes to look for a job, you know, by the time you're coming to interview, it may be that there's only 4 months left on your visa, and there is no guarantee that you'll be granted a further visa. The, you know, resident, if you are applying for residence, that process can still be quite uncertain at that point. So whether an employer is willing to hire someone in that kind of uncertainty, you know, it's a very difficult situation to be in. But another difficulty is that the way Immigration New Zealand interprets this visa category is that those work visas can only be granted once. And so often people have to request another work visa. And again, there's uncertainty around that because Immigration New Zealand view it as making an exception to instructions if they grant a visa again. So again, yeah, the challenge then is trying to find work in that time, but also the residence visa applications tend to take quite a long time to be processed. So you need to stay legal, you need to have a valid visa while your residence application is being processed. And so it's having to go through this application process maybe multiple times, which is a stress every time, which could be addressed by lengthening.
Kia ora, thanks, Megan. Sarah, we'll come back to you. You mentioned earlier the issue of offshore abandonment. Do you want to talk a little bit more about what that means and why that's a current risk for victims?
Yeah, so something we've seen quite a few community law clients face is this form of abuse that's known as transnational abandonment. And it's where a partner tricks or coerces them into returning to their home country for a visit. And then once she's offshore, they refuse to get her a plane ticket back to New Zealand or even try and get her visa cancelled while she's out of the country. And this abandonment is done with the intention of stopping women from accessing their legal rights in New Zealand, like their rights to relationship property or the right to participate in criminal or family court proceedings against their abusive partner. And it can also separate them from their children or leave them to a life of really serious hardship and stigma. Immigration policy really entrenches victim survivors' vulnerability to this kind of abuse, because once the temporary visa holder is offshore, their visa can be cancelled without consulting them. And so we've often seen partners trying to do this, trying to contact immigration once their partner is offshore to try and get her visa cancelled. And because she's offshore, she can't then apply for a family violence visa because she's not physically in New Zealand, which is one of the visa requirements. It's a gap in policy that I think really needs to be addressed. Possibly we could give women offshore access to the family violence work visa, and that would enable them to return and to access their legal rights in New Zealand.
Thanks, Sarah. Vasu, what type of financial support, if any, or social support is available to victims while they apply for the family violence visa?
So clients, like, there is no financial support available to them. It's if they are partner, in my case, I was a partner of a non-resident and a non-citizen. So I had no rights to benefit. There was nothing that, like, no kind of financial help available for me and my kids. I mean, if you have kids, it makes the situation even worse, because then you have extra mouths to feed. Most people who are going through family violence are also facing financial abuse. So they absolutely have no money when they leave the relationship, like it was in my case. We've had clients at Community Law Wellington and Hutt Valley who have had no money for buses to go and see their lawyer or go to the court appointments. We've had a client who was in the safe house for 18 months with a very young child, dependent on them for money for food and for travel to make it to her the legal appointments. If they are on a family violence visa, they can get emergency benefit, but that must be renewed weekly, and like they have to check in weekly with work and income to see if they can still get that. So basically they are left with no financial support. This makes them, like, in lots of cases, either go back to the abuser or not leave, and also makes condition ripe for the abuser to abuse them even more, knowing that, like, they have nowhere to go. Yeah.
It's setting up some quite significant forms of entrapment, isn't it? If there is no financial support whatsoever for women, and the stress they're already experiencing violence, and then also having to navigate complex government systems to try and get any support at all, on a weekly basis, if there's anything available at all. So some quite significant issues there. Dylan, we might switch over to you now. The government is currently implementing some changes to immigration settings. Is that changing anything for victims of violence? What are the impacts for victims applying for the family violence visas?
Kia ora, Charlotte. Yes. So the Great Immigration Reset, which is the new policies that are in place in response to the borders reopening. Look, unfortunately, in my view, these policies do very little to support or acknowledge victim survivors and victims of family violence, and they reflect quite patriarchal and outdated attitudes, in my view. Now, let me explain. So at the moment, a work visa holder can support a work visa for their partner, provided their visa holder is paid the median wage, which is currently just over $27, but it will increase to almost $30 from the end of February next year. There's a slight exemption for tourism and hospitality. However, from December, which is obviously in a few days' time, these requirements are becoming more onerous as part of the immigration reset. So the reset policies are very much focused on fast-tracking residency for high-skilled migrants. A key initiative is the Green List, which is a list of highly skilled roles in ICT, engineering, consultancy roles, where there are not enough New Zealanders to meet demand. So depending on the Green List, a person has either the option of a straight to residence pathway or a 2-year work to residence pathway. So from December, if a work visa holder has an occupation on the Green List, or they are paid twice the median wage, then they can support a work visa with open work rights for their partner. Otherwise, their partner is only able to get a visitor visa. Now, this leaves a person very dependent on their partner for income. Green Party MPs have said that this policy change is likely to increase the risk of family violence and also worker exploitation, and many people will be forced to work in breach of visa conditions in order to have financial independence. So in my view, this new policy is patriarchal because the visa holder, who is usually a man, will be the principal applicant. And under the new policy, their partner is a visitor. So there's a dynamic, a power imbalance here that is perpetuated and in fact labeled so in the policy. For the woman to have some financial independence, she will need to obtain an accredited employer work visa themselves. This is a challenging and daunting process, much more restrictive than I understand the short-term visas that Vasu was able to get in her circumstances. So under the accredited employer work visa scheme, there are 3 key steps. Briefly, the employer has to be accredited, which is a fee to the employer of some $740. The job check has to be done, and that's another $610. And then it's only once those 2 steps are complete that a person can apply for a visa, which costs them $750. Now, if they're granted one of these work visas, then they can work less than 30 hours a week, which seems to be, I think, the government recognizing that partners may have childcare and other responsibilities. But look, overall, it's a very complex scheme. I've talked to various employers in the work that I do, also through community law on migrant exploitation. And many people are very reluctant to engage with this very complex, lengthy scheme. And yet the government is saying that partners of work visa holders have to go through all of these steps while they are on a visitor visa. And a visitor visa is exactly how it sounds. It's for visitors. It's available for holidaymakers, people visiting family and friends. There's an assumption that someone temporarily. So I think that this policy fails to support women who are experiencing family violence in at least 3 ways. First, they may apply for the family work visa, but it will be harder to prove to Immigration New Zealand that while on a visitor visa, they had intended to seek residence on the basis of their relationship. It could be easier for the abuser and also Immigration New Zealand to claim that the woman was not in a genuine, stable and enduring long-term partnership, as Sarah has explained. These are all criteria for the visa, but I think it could be very difficult for someone to say that their relationship had all of these characteristics while they were on a visitor visa. Second, I think it could be harder for a victim to leave an abusive relationship while on a visitor visa because they're left in a very vulnerable, additionally vulnerable situation. They have no access to benefits. They're reliant on their abuser for financial support. And as others have said, it's very difficult to search for work while on a visitor visa. The very first question that a prospective employer will ask is, do you have the right to work? And you do not on a visitor visa. So I think that this will result in increased feelings of entrapment for a person in an abusive relationship. And in turn, the abuser will be able to exert greater coercive control, basically using that insecure immigration status as a tool of violence. So I think that the new policy does create these additional barriers for a victim. it's such a massive step to go from someone who is a visitor in New Zealand to being someone who can live independently of an abuser. You know, the minister, when announcing the reset policy, said that getting our immigration settings right is a balancing act. I don't think the needs of vulnerable women who are experiencing family violence have been appropriately considered with this policy. And the third problem I'd like to highlight with the policy is that currently, if the abuser is on a temporary visa, such as a work visa, the victim may be able to apply for a family violence work visa as an exception to instructions. This is fully at INZ's discretion, but we have been able to support some clients to get a visa as an exception to instructions, even where their abuser is not a citizen or resident. But I do think it's going to be much more difficult for INZ to grant a visa as an exception to instructions under this new accredited employer scheme because of that three-step process that I've outlined. It's not so simple to sort of, I think, say, well, you don't meet the family violence requirement, so here's an accredited work visa as an exception to instructions. I just think that that's going to, INZ will find that difficult to do. So I think just to summarize, I do think that the new policies, the new work policies, the new you know, sort of visitor visa status for most women who are partners of work visa holders, I think that is going to, unfortunately, as the Green Party MPs have highlighted, place additional barriers in place and make it harder for women to leave abusive relationships.
Thanks, Dylan. Just wondering, Sarah, how we compare internationally with these policies. What does that look like in terms of a comparative analysis?
Well, interestingly, the family violence visa policy states that its objective is to uphold our international obligations, and these are the obligations to protect children from violence and to end discrimination against women in family relations. But I think that, you know, our scheme is so narrow that it really fails to uphold these obligations. Children's interests aren't even relevant to any of the visa criteria. There's not really any scope to consider them. And most migrant women can't realistically access the protection of the visa if they experience violence. So what I think has maybe happened is that in writing and applying the policy, New Zealand hasn't interpreted that obligation to end discrimination against women in family relations in a correct way. The UN Committee on the Elimination of Discrimination against Women has made it very clear that domestic family violence is one of these forms of discrimination against women that states must eliminate. But I think in the context of these visas, New Zealand has interpreted that discrimination in family relations in a much narrower way as being an obligation to protect women from cultural stigmas against divorce, rather than New Zealand's obligation to protect all women within our borders from family violence. I think if we were really trying to protect all women from violence, we wouldn't be excluding so many from the protection of the visa. And our criteria are, like I mentioned earlier, much narrower than comparable schemes in countries like Australia, the US, the UK, which don't have anything like that unable to return home requirement. And the focus of those schemes internationally is making sure that women who had a pathway to residence don't lose it and aren't sent home as a result of reporting violence, whereas ours is just for women who can prove really serious risks in their home country. And it's now been over 20 years since these criteria were written, and it's, I think, really time to look at how far behind other countries' schemes that we've fallen, and especially to remove that unable to return home requirement. Another way that our system is quite different is in how few forms of family violence evidence we accept. So, for example, in the UK and Canada, there's no closed list of acceptable evidence. And similarly in the US, they will accept any credible evidence. And Australia also has a discretion for immigration officers to accept quite a wide range of evidence. So it's another area where I think we have a lot to learn from other countries' systems and need to review our policy to keep up.
Kia ora, thanks, Sarah. I guess looking at what we can change or what needs to change going forwards, if I can hand over to Megan and Dylan, what possible options is the government considering to address these issues? And what are some of the benefits or challenges with those options? Megan, do you want to maybe start and Dylan can come in after?
Sure, thanks. So we understand that this policy, this category is due to be reviewed next year in 2023. The difficulty that we have with that is that subsequent ministers have committed to review this visa category for a really long time. I started working in this area in 2012 and Nathan Guy was the minister at the time, and he publicly stated that there would be a review. And some INZ staff at the time that I was corresponding with thought that the review was ongoing, but nothing ever came of it. There's also been a number of all of government consultations, the joint venture as well. And so while we're hopeful that we'll see a review, I guess we haven't heard any detail yet about that review. And it's really important that it's a comprehensive review that addresses all the issues that we've raised, not just a few tweaks. So some of the things that we've raised that really need to be addressed is the length of the visa, access to the visa category by partners of temporary visa holders, not just partners of citizens and residents. The issue around inability to return to one's home country really needs to be addressed. And so does that narrow category of evidence. We need to see that made much broader. We would also like to see access to legal aid and access to benefits that would require legislative change. So Jan Logie has introduced a members bill that actually addresses all of these issues. It's a really comprehensive bill and it hasn't been drawn yet from the tin. What we'd really like to see is the government pick that bill up. And one of the real pros, one of the positives of picking that bill up would mean that it's protections for family violence survivors are then in legislation and can't be changed as easily as policy can. But legislation isn't required other than in order to get legal aid made available and to get access to benefit, legislative change is required. But for the immigration changes that we'd like to see, legislation is not required. This can be done through policy. So those are, I guess, the two avenues that we see for change. But like I said, I guess we're waiting to hear what happens next year. Dylan, do you want to add to that?
Yes, thanks, Megan. So I think Megan's covered Jan Logie's bill really well. But if I could just maybe refer to some of the operational matters that we see very frequently with the clients that we help at Community Law Wellington and Hutt Valley. And look, these are really down to, I think, just improvements that can be made in the way that applications are assessed. I know that there is a high staff turnover on many of these teams that are looking at these applications, but I do think that there are some really fundamental things here that we would love to see some improvements in. So often there is quite a lack of empathy in officers processing these applications. So we're seeing them ask questions about things, like someone's qualifications or where, even basic things like where do they live. These matters are all covered very comprehensively in our client statutory declarations. And it suggests to me that, are the officers actually reading the applications properly? Clients tell us that they're feeling like they're not being heard, or, having to go over events again and again can be re-traumatizing. And there doesn't seem to be too much, I think, sort of deep empathy about a victim survivor's circumstances. The default position should be that women are speaking the truth and are to be believed, not that their applications contain untruths which must be uncovered. But unfortunately, that is how some applications are treated from my perspective. the DV program payment that Vasu and others talked about is available, but it is very difficult to access. Very recently, an MSD officer refused to grant a client time for an appointment even to discuss her eligibility. She had just been granted the family violence work visa and was eligible for this payment, which is equivalent to the job seeker payment. But the MSD officer, even though we pointed out, where on the website, there's information about the payment, because it's not sort of commonly, I guess, used. But even with that information, the officer said, no, you're on a temporary visa. You have no right to the job, to a benefit under the scheme. So things like that are just really basic improvements in operational practices that really need to improve. Another one is, there's an extra security clearance check for clients from certain countries like Pakistan, China, Palestinian women, Arabic women. In my experience, this profiling is unnecessary, and the additional time it takes to an application, which can be 9 months or more, adds enormous pressure to family violence victim survivors. Another concern is, just the practicalities of getting the declarations, which Sarah has talked about. These are so hard to get when you have no income, and we're now seeing GPs, who are one of the narrow, groups that can provide declarations, charging $250 for providing a declaration. And when you're someone who does not have an income, doesn't have access to any benefits, you're basically reliant on support services to fund the costs of a declaration like this, as well as maybe medical costs, the costs of getting a police certificate. Australia now requires a fingerprint check. That's another $200. If you've lived for some time in Australia, you're required. INZ has recently insisted that a client who only spent a few months in Australia had to go to the cost of expense of about $200 to get a fingerprint check from Australia. Sorry, my list is quite long. The requirement to show proof of custody, which is not a family law term, or evidence of rights to remove children from their country of residence, is really problematic. And it requires a father who may actually have no, that the parenting order may have no visitation rights or anything like that, and the father might be just not wanting to be involved at all, and yet able to withhold consent to a child being included in the mother's residence application. And we have seen that happen. I think Te Aotearoa Kura, to me, was all about mobilizing support, coming together, us as a nation saying, we care and we need to do better for victims of family violence. And it's really frustrating as seeing all of these operational barriers put in place that prevent women from accessing the support they need. The support that they need should not be contingent on immigration requirements or their immigration status. That's basically not putting the needs of women, victims and children first. So,
Kia ora, thanks, Dylan. A really succinct outlay of just some of those incredible barriers and challenges faced by migrant women in particular. Thank you to all of our panellists for your input and deep knowledge and expertise thus far in our webinar. I'm going to start having a look at some of the questions that have been popping up in our Q&A from our audience, and maybe throwing it open to you to start responding to some of these. One of the first questions we have is actually about understanding what the different challenges that may be faced by migrant survivors who are from the rainbow community and seeking to leave violent partners. Those issues are incredibly complex, as coming out might not be safe for them, and different issues too in terms of whether they would be safe in their country of origin. Have any of the panellists here had experience working or supporting migrant victim survivors across these issues?
Yeah, I have at community law, and Dylan as well can probably speak to this. I guess, unfortunately, the response is that rainbow victim survivors are basically invisible in the visa policy, and the way in which the visa policy is designed can really disadvantage them and make it hard to access the visa, despite the fact that, you know, of all of our clients, they're often the ones that would face some of the greatest discrimination if they had to leave New Zealand. But the policy is written in a way that really focuses on heterosexual relationships. You know, the objective statement talks about ending discrimination against women in marriage and family relations. And appeal decisions have kind of narrowed that scope even further. The Immigration and Protection Tribunal, which is the body that hears appeals against the decline of these visas, they have said that the stigma that applicants must prove can't just be any stigma. It needs to specifically be stigma against separation in the context of family violence. Whereas the main stigma that our rainbow clients have faced usually relates to their gender identity or their sexual orientation. So arguably, if it went to appeal, they would fall outside what the IPT has interpreted the rules as. And that uncertainty over whether or not they can fall within the policy is obviously a massive barrier to reporting violence and to separating. But also, as the person that asked that question touched on, just the providing evidence from, you know, support services or community members can be really hard, particularly if you're not out yet. And the evidential requirements for proving family violence can be a huge problem in that way, because, you know, we know that there's massive additional barriers for rainbow victim survivors in accessing the justice system or accessing professional support, and they're much more at risk of receiving responses that are discriminatory or that lack understanding. And the violence that they're experiencing may have been a lot less likely to come to the attention of the justice system. If they're from a community where rainbow identities are really heavily stigmatized, they're much less likely to have disclosed the violence or sought help, or potentially even no one knows about their relationship, which can be a whole other problem, because you also have to show that you were in a relationship and intended to seek residence based on the partnership. But if your community didn't know about the relationship, it can be hard to prove the partnership in the usual ways, like, you know, support letters from community members saying that they knew about your relationship. Rambling a bit, sorry, but the short answer is that the evidence requirements are a real problem and need to be made more flexible to account for what rainbow victim survivors realistically can provide.
Thanks, Sarah. Did any other panelists want to add anything onto that as well?
Sorry, Charlotte, just add, and I saw that this in the question Q&A as well, but there is an organization called Aotearoa now, and also Indian Pride, who are start looking into this. So probably if you are a migrant person and you are from the rainbow community, those organizations are really good to approach for support. Thank you.
Sure, thanks, Silvana.
Charlotte, maybe just to briefly add, so yes, completely agree with what Sarah said, but even though the requirements and the evidential requirements are very much around the stigma someone would face in the context of family violence, that certainly doesn't stop us at Community Law putting absolutely everything we can into our applications, into our submissions, supporting. So in this context, if there's additional stigma because of someone's sexual orientation, absolutely we make the case for that stigma is stigma. In this particular situation, a couple of years ago, we were actually successful with that. So I guess, you know, you just don't know what might be in the minds of the particular officer who's assessing the case. So we absolutely make all of the arguments that we have available to us.
Kia ora, thanks, Dylan. There's another question which I think is related to this, which is actually asking about older migrants who may be experiencing violence, not from an intimate partner, but actually from adult children, for example, and whether they have any kind of access to family violence visas, or what does that mean in terms of violence they be experiencing that's not intimate partner violence?
Unfortunately, in that situation, this family violence visa isn't available. So the criteria of this visa is that you have to have been in a relationship, in a partnership with a New Zealand citizen or resident and intended to seek residence on that basis. And so it doesn't apply to that elder abuse type scenario. In the situations that I've seen, the most obvious path available has been going to the minister to ask for a special direction, because there is no other visa pathway available in that situation. I mean, there's a whole range of issues with parent category as well, which, you know, it may not be the most appropriate category if that abuse is going on. But yeah, it's a really, really difficult one. And yeah, like I said, there's probably much more policy work that would be required around that particular issue.
Kia ora, thanks, Megan. Anybody else wanting to add in anything there at all? We've had a question around, could some clarification be provided around the emergency benefit provided by WINS? Can this be accessed by those that have recently got their family violence visa, or do they have to be permanent resident holders, which is what happened in a few situations this person has encountered?
I can probably take that one. So as different people have alluded to, there is a family violence program payment, which is actually a type of special needs grant. I think it was created that way because it was the only way a benefit could be granted without requiring legislative change. So it was put in around 20 years ago when the family violence visa was introduced to specifically be given to family violence work visa holders. It was meant to be a temporary thing from what I can find of the policy discussions at that time, but somehow we've still got the same scheme 20 years later, and it really isn't as effective as it could be. It's really limited. When you're on that, you're not on a main benefit, so you can't get the additional things like temporary additional support that most benefit holders can access. Like Vasu mentioned, you have to renew it every week, which can be a real, there have been a lot of improvements to that process, but in the past we've found clients have had an awful time having to go into a WINS office, see a different case manager every time, disclose the violence to a new person, convince them that there is this benefit category they're entitled to, because most frontline workers don't know about it. Really, really taxing process for a really small payment that's a lot less than what other beneficiaries can access. Once you've applied for residence, things are a little better. Sometimes we have had success then getting clients onto the emergency benefit, which is a regular main benefit that you don't have to renew every week. But it's a bit tricky to do that. You have to apply. So the wording in the legislation is that to be eligible, you need to have applied for residence because you are required to stay in New Zealand due to unforeseen circumstances, something like that. So once the residence application is in, it might be possible to shift to that, which is a better benefit to be on, and also comes with other entitlements around additional financial support, social housing, that kind of thing. But if you're someone in Vasu's situation and you can't get any kind of family violence visa, you're trying to get residence through some other pathway, there is nothing, no support whatsoever. So really depends on whether someone's going to meet the family violence visa criteria.
Thanks, Sarah. We've had a question, do you know if there are many people who could not receive family violence visas because of the acceptable standard of health policy?
Maybe I can address that one. Most of the applications I've seen, that hasn't actually been an issue, but it definitely has the potential to be, particularly for people with disabilities. And I also did mean to mention that when I was talking about the issue around older people as well, that potentially could come up as another barrier. One of the difficulties, though, that we see is around our clients being able to afford the medical checks as well, because as Sarah mentioned, you do need to still, show that acceptable standard of health. So you do still need to go through that medical check process, and that's another significant expense that women and their children face when going through this application process. So the acceptable standard of health issue is a risk or a barrier or a requirement for you know, a whole range of different applications, including the family violence visa category. I'm not sure if anyone else has had any difficulties with this particular requirement.
I'm just thinking also that family violence as a cause of significant poor health outcomes, you know, may actually be contributing to people's ability to meet health standards. You know, that victimization, either physical or emotional, obviously can have significant lasting impacts. So, you know, that may come into play as well.
Maybe if just to note again, the costs, so the costs of a medical and a chest x-ray together are, you know, somewhere in the region of $600+. So that's an enormous expense for a person, especially if they're not working, if their partner is controlling the finances, if she's contemplating separating but has this huge expense that she knows she has to you know, she has to meet before she can, you know, even apply for the visa. So it would be wonderful to see some government support provided actually for expenses like medicals, costs of police certificates. Yeah.
Well, I remember that, that in my case, when I was granted residence through the minister's discretion, and then I had to provide chest x-rays for my son, who was 13 at the time, and it was a huge cost. And I was really worried that he had pneumonia twice. So I was like, oh God, what if it comes, like, you know, and I was like, it was just like another added stress that, okay, you can get residence, but then you have to meet the health criteria or the character requirement that they ask you. And like, what if his x-ray shows that he has pneumonia and we won't, like, you know, will he not get the residence, or what will happen? So I just feel like for children, like as young as 13-year-olds, those kind of like requirements shouldn't be there.
And then if something is, you know, I've seen sort of medicals come back with sort of saying, oh, there's something possibly going on here, but nothing conclusive. And yet INZ has then required a consultancy report, which can cost thousands of dollars in order for there to be an acceptable standard of health, you know, confirmation. So again, incredibly cost prohibitive.
If I could just make another quick point on Charlotte, the health impacts of violence that you talked about is one of the many problems with the really short duration of the family violence work visa, 6-month duration, is that women can't access publicly funded healthcare. So generally, you have to either have a visa that allows you to be in New Zealand for 2 years, or the duration of your current visa plus the time you've lawfully been in New Zealand must be at least 2 years. Because that visa is only 6 months, a lot of women aren't eligible for funded healthcare, which means they can't access support when they have, you know, faced health impacts of the violence they've been through. And in some cases, we've even had to get involved in disputing bills from hospitals that clients have received because they sought help after an assault. So yeah, and another really important reason why that visa length is just insufficient.
Thanks, Sarah. Really important points there. Coming back to thinking about children, there's a question here around, is there support for victims of family violence with children who have disabilities? For example, the child disability allowance, is there any possibility of access to that at all? Generally, that's
No.
just a no.
No. We have been supporting someone whose child has some health needs, which means that it's absolutely impossible for her to actually separate from her partner because she's unable to work to afford the childcare that he needs, and she's actually completely trapped in that situation. But so if she could have had access to some financial support that would then have allowed her to work, to give her that bit of confidence to say, well, look, I can actually envisage an independent life, and I can do this. But right now there's nothing. She's completely reliant on her partner for any form of finances. So the entrapment is enormous.
Thanks, Dylan. We've got time for, I think, one final question before we wrap up today's webinar. There's a question here in terms of actually shifting a focus and thinking about perpetrators of violence, and are there any limitations or restrictions in terms of immigration visas?
Yeah, so one of the things that we've often heard raised as a reason for not expanding this visa category is that people whose ex-partner has obtained a family violence visa because of violence by them can't go on to sponsor further partners in future. In reality, I have yet to see an example that has been appealed where that person hasn't ultimately been allowed to sponsor another partner. So on paper, they are barred from bringing in future partners and sponsoring them for New Zealand residents. In practice, I think when challenged, they tend to succeed in being able to sponsor again in future. There are character checks that are done on the perpetrator as they're sponsoring their partner that should show up any history of convictions for family violence offending. It can be a really problematic area, and we've actually ended up supporting some clients who have decided to stay in their relationship, supported them in challenging immigration's refusal to recognise the relationship because of violence. Where they have said, you know, this isn't a genuine and stable relationship because there's been violence, we won't grant you a partnership visa. The person being penalised there is the victim of violence. And that's really problematic. And, you know, survivors know that that's what will happen if immigration becomes aware of the violence, and it becomes a huge deterrent to asking for help. So I think there needs to be a bit of a change of thinking around not taking any compliance action against survivors when immigration become aware of violence. I'm not sure if I've explained that very well. One of you guys might want to jump in.
I think you explained it really well, Sarah. But I just wanted to add that, yeah, we have seen resistance from Immigration New Zealand to making this category easier to access, because what about the poor men who won't be able to sponsor applications in the future? And assessments on the impact of the impact on perpetrators. And so I think that's a really misplaced concern in terms of ensuring the safety of migrant women and their children. And yeah, the issue of fraud has also come up as a concern by INZ, that, you know, people might fake evidence in order to access this visa category. I think it would be one of, if not the hardest visa category to put in a fraudulent application. I think if you're going to do that, there's probably easier categories you could go for. But that has been those two issues, the impact on perpetrators or sponsors and the suspicion of fraud, have been two big barriers that we've come up against when we've been advocating for change.
Yes, I remember once I asked some MPs and they told me that family violence couldn't be an automatic green card. So that, really shows that they think that people are going to misuse, this category and try to stay. But like Megan says, it's so hard, and it's really frustrating to see. And actually, after listening to this webinar, and so you get even more sad, about how difficult the system is here, making it for migrant women, who want to stop violence. In between the financial difficulties, the court processes that they have to go. Some women have been having to pay huge amount of dowry to get married in the first place. So you already come with huge debt into here, and having to do all this fight with English as a second language, no support, no networks, and in 6 months, I honestly believe that this is completely against human rights.
Thank you, Silvana. On that note, we're very, very close to being at time for today's webinar. So I just want to thank everybody for your time, and sorry we couldn't get to everybody's questions. There's a lot to discuss, and I think we've covered a huge breadth of the issues today in our discussion already. I think it's so important that people understand these issues, and that building knowledge within our communities is a definite lever for change. And if we know that there is a review coming, that we can actually communicate you know, these issues to the people that actually can make changes in policy. Megan is shortly going to share a slide with some contact details for anybody who would like further support. And just a reminder that today's session has been recorded. We will send an email in a few weeks with links to the video and an edited transcript and some of the references that we have discussed today, so that we can all continue our learning. And also, if anyone is interested to sign up to our mailing lists from the clearinghouse, you can visit our website, nzfec.org.nz, and down the bottom there's an opportunity to sign up for news alerts and events alerts in our Pānui. This will give you information about future webinars, including an upcoming one from Sarah Croskery-Hewitt on some more of her in-depth look at some of her research. I just want to finally thank all of our panellists today, and also to our wonderful tech support team, Megan and Owen, for your support in making sure everything has run really smoothly. I hope that everyone has a safe rest of your week, that you stay hopefully healthy in the lead up to the holidays. So thanks again, everyone. Ngā mihi nui kia koutou. Ka kite.